Welcome to Dorsey and Whitney's semi-annual M&A update. I'd like to introduce Brian Burke, a partner in Dorsey's M&A group. Take it away, Brian.
Thank you. Hello, everyone. Good afternoon, and welcome to the March 2021 edition of the M&A Update, our semi-annual look at corporate law developments of interest to the M&A practitioner. I'm Brian Burke. I'm partner in our corporate group here in Minneapolis, and I'm joined today by Amelia Messa, beaming in from our Delaware office, as well as John Van Horn, also from our Minneapolis office. It has been quite a year in a number of ways, and M&A case law is no exception. As usual, we'll be focusing most of our time with decisions coming out of the Delaware courts. But before we get to those decisions, we have a number of news items to update you on from the Delaware legal world, including a pair of noteworthy retirements. The first, of course, is the retirement this past year of our very own Bryn Baylor, who retired from Dorsey and Whitney in June. Bryn gave the very first M&A update presentation to Dorsey colleagues and clients in 1994 when he discussed the Delaware Supreme Court's decision in Paramount. And with its success, it grew into a semi-annual presentation that he continued to host over the next 26 years. So a heartfelt thank you to Bryn for your contributions over the years, and we wish you the best in retirement. But Amelia, Bryn is not the only noteworthy retirements coming out of Delaware.
He is not. We also have Chancellor Bouchard, who announced his retirement from our Delaware Court of Chancery, effective as of April 30th. Bouchard was sworn in as Chancellor May 5th, 2014. Prior to serving on the bench, the Chancellor was the managing partner of a law firm that he founded, and before that, he was a litigator at Skadden Arps in Wilmington. Nothing has yet been publicly announced as to what his future plans are, other than spending time with his family. However, a lot of times when judges come off the bench, they do tend to go back to serving at a law firm, so we will see where he ends up. During his time on the bench, he was obviously very widely respected amongst the Delaware community. One of his greatest achievements was that he oversaw the court through an expansion, adding an additional 2 vice chancellors, really due to the basically impossible caseload. And then most recently, he has led our court through this pandemic. He presided over many well-known cases, including the proposed merger of CBS and Viacom. Unfortunately, a couple of years ago, after the TransPerfect case, some of the litigants weren't very happy with how things were decided. They kind of came together and made a very public attack campaign against the chancellor. This was really unprecedented in the state of Delaware. In response, a lot of attorneys and the Bar Association came out very publicly and supported the chancellor. So in terms of what's next for our Court of Chancery, interested applicants have submitted their interest to sit on the bench for the open seat. Recently, the Delaware courts, along with a lot of other courts around the country, have been pretty criticized for their lack of diversity. In Delaware, it's really been the Delaware Court of Chancery and our Supreme Court. So it'll be interesting to see how this spot is filled, which we will know by the time we get to our next M&A update, and we will fill you in then. In terms of the current state of our Delaware courts, much like other states, our other courts around the country, due to the COVID pandemic, our courts are not fully up and operational. We are currently in phase 2 of the reopening plan. It's a lot like other things that you see around the country right now. If you go to the courthouse, there's going to be temperature checks, COVID questionnaires, masking requirements. There's limitations on the number of people that can be in each room of the courthouse. Our courthouse buildings are limited to a 50% occupancy right now. Jury trials are on hold. We have resumed grand jury trials, but basically anything, especially civil things, are happening all over Zoom. It's unclear right now, but like most things with the pandemic, when we're going to move to phase 3, which will provide for more in-person proceedings. We do have some good news from Delaware this year, and that is that our statutory amendments were all passed on time. As you may know, Delaware is a bit unique where we actually amend our entity statutes every single year, with the exception of our Statutory Trust Act, which is amended every other year. They typically go into effect on August 1st of each year. We were a little nervous with the pandemic because our legislature was only hearing emergency legislation for some time. But over the summer, everything was passed and everything went into effect on time. So with that, John's going to touch base on our Dgcl amendments.
Thanks, Amelia. And yeah, it's comforting to know even in a pandemic, some things do not change. House Bill 341 was signed into law in July, with many of the amendments to the Delaware General Corporation Law contained in the bill becoming effective upon signing. Among the package of amendments was an amendment to Section 110 of the DGCL. Section 110, which dates back to the Cuban Missile Crisis, provides boards of directors with the power to adopt temporary bylaws during emergency conditions resulting from military hostilities, civil unrest, infrastructure outages, or extreme weather events. The amendments to Section 110 expand the circumstances where a board can adopt emergency bylaws to include an epidemic, pandemic, or the declaration of a national emergency. This amendment took effect retroactively back to January 1st, 2020. The second amendment noted here relates to Section 145C. Under Section 145C, a Delaware corporation is required to indemnify its directors and officers under certain circumstances. Prior to the amendment, the term officer was undefined. The amendments provide that the officers entitled to mandatory indemnification under 145C are limited to the list of officers that we've included here on the slide. In addition to that list of officers, in the case of a public company, any officer identified by the corporation as being among the most highly compensated officers in a public filing is an officer for the purposes of Section 145C. So with that, I'll send it back to suburban Wilmington.
So with respect to our alternative entity amendments this year, there really wasn't anything huge that happened with respect to LLCs and limited partnerships. Most of the amendments are really just cleanup things, some technical changes, things that really won't impact anybody tuning in here today. The one that got kind of the biggest press was that we have confirmation that there's no default appraisal rights. However, there's never been default appraisal rights. It really was just a rewording of the statute to make it line up with the wording throughout the rest of the statute. So to the extent that you want an LLC or a partnership to be treated more like a corporation and have appraisal rights, you just need to build those into your LLC or partnership agreement. We did expand on some prior amendments allowing more use of electronic signatures, electronic record keeping, really just to keep up with the times and the way that people are actually doing business these days. On the statutory trust side, we now allow for a division of statutory trust. A few years ago, we allowed that division for LLCs, followed by limited partnerships the next year. For anybody who doesn't know what division is, it's basically the opposite of a merger. So with a merger, we have two companies that come together to become one. A division allows a company to split apart its assets and liabilities into two or more companies. I don't expect it to be very widely used in Delaware. It's been around now for a couple of years for LLCs, and only a handful of them have actually been done. And if you think about the fact that we have over 1 million LLCs in the state of Delaware right now, it really is very limited in its use. But a good thing to note that it is out there and available in case it makes sense for you.
Excellent. Thanks, Amelia. So over the last 6 years, we have watched closely as the Delaware courts, led by former Chief Justice Leo Strine, have completely reshaped the M&A litigation landscape. They have done this primarily through 4 main lines of cases, which have curtailed, or at the very least, transformed M&A litigation in Delaware. We've talked about each of these cases and their progeny before. So to quickly run through them, first, there's the Trulia case, in which the Delaware Chancery Court announced a strict new plainly material standard for approval of disclosure-only settlements in M&A litigation. And it was an enormously important step in eliminating the M&A litigation mill in Delaware, in which minor disclosure changes were traded for large plaintiffs' counsel fees and universal releases for the defendants. Now those disclosure changes have to be, quote, plainly material, and as a result, plaintiffs have moved those strike suits to other jurisdictions with mixed success. Second, Kahn versus M&F Worldwide, what M&A lawyers refer to as the MFW case, in which the Delaware Supreme Court held that a controlling stockholder M&A transaction that would otherwise be subject to entire fairness, the most stringent review, are instead subject to the business judgment rule and subject to dismissal on the pleadings if certain procedural safeguards are in place from the very start. We'll talk about those later today. Third, Corwin, The Delaware Supreme Court held in Corwin that if a merger does not involve a controlling stockholder, then the irrebuttable business judgment rule applies to post-merger damages claims where there has been fully informed, uncoerced approval by a majority of disinterested stockholders. And that's even if an enhanced standard of review like Revlon or Unicel would otherwise apply. And the fourth line of cases dealt with appraisal, where in the DFC and Dell decisions, the Delaware Supreme Court made it clear that deal price minus synergies should normally be given the greatest deference in determining fair value for purposes of Section 262 appraisal. Absent clear process failures in the sale process or some other incredible market irregularities, discounted cash flow and other expert methodologies, which in the past resulted in some jackpot valuations for plaintiffs, those are going to be the exception and not the rule under Section 262, thus making statutory appraisal a far less attractive litigation route because those jackpots will be few and far between. So today we'll be focusing on two of those lines of cases, Corwin and MFW, where we saw some new decisions with some important developments that every M&A practitioner should be aware of. So first up, Corwin and its sister case, Cornerstone. John?
Hey, thanks, Brian. So we'll start with a review of the Corwin line of cases. Now, before being allowed to join the M&A Update franchise, I was required to sign an undertaking that requires that I mention the role of the Dorsey and Whitney Foundation lecture in the Corwin creation story. By the time Vice Chancellor Travis Laster joined us at William Mitchell School of Law in the fall of 2013, it was absolutely routine that within days or even hours of the announcement of a public company deal, multiple class action stockholder lawsuits filed in multiple venues would be filed challenging the transaction. These lawsuits would allege that the public target's directors had violated their fiduciary duties in evaluating the sale transaction, in addition to frequently alleging deficiencies in the disclosure provided to stockholders about the deal. The cases were frequently settled, as Brian noted, for nothing more than the target making additional disclosure of questionable value and plaintiff's counsel walking away with a handy fee. With the litigation settled, the transaction would typically proceed to closing with the overwhelming support of stockholders. Now, one factor contributing to the widespread settlement of these cases is that application of Revlon's enhanced scrutiny standard made even the most meritless case difficult to dispose of with a motion to dismiss. This created inherent settlement value in the cases, which a class action plaintiff's bar had exploited to the point of creating a de facto transaction tax for the acquisition of publicly held targets. In his remarks in St. Paul, which were later developed into a law review article, the Vice Chancellor described to those of us in attendance his view that the role an informed stockholder approval should play in altering the framework for judicial review of change in control transactions. Well, by 2015, Vice Chancellor Laster's frivolous lawsuit Death Star was fully operational. In 2015, the Delaware Supreme Court affirmed the Vice Chancellor's holding that in a merger not subject to entire fairness review that is approved by a fully informed, uncoerced majority of disinterested stockholders, the appropriate judicial review standard for post-closing damages claim is the business judgment rule. As Brian noted, this is the case even if enhanced scrutiny standards like Unicel or Revlon would otherwise apply, for instance, in the case of litigation seeking pre-closing injunctive relief. In a subsequent cleanup operation, Chief Justice Strine, writing for the Delaware Supreme Court, made clear in the 2016 Attenborough case that following the fully informed, uncoerced stockholder vote, the only remaining duty of care claim against directors is for waste, essentially creating a supercharged business judgment rule that applies after a cleansing Corwin stockholder vote. In another 2016 case, Corwin's principles were applied in the context of a two-step tender offer. So in the tender offer, the fully informed, uncoerced tender of a majority of shares held by disinterested stockholders has the same cleansing Corwin effect that a fully informed, uncoerced stockholder vote has in the case of a statutory merger. The Volcano case also introduced to us a new shorthand expression, which Brian referred to before, of the Attenborough holding. Once invoked by a fully informed, uncoerced stockholder vote or tender, an irrebuttable business judgment rule standard applies, which can only be overcome by a showing of waste. Together with the Trulia line of cases, Corwin has transformed the volume and nature of deal litigation flowing through the Delaware courts. The ability of defendants to dispose of what would have been post-closing Revlon cases with a motion to dismiss has massively shifted the incentive of the plaintiff's bar to bring cases based on alleged breaches of fiduciary duty. The result is far fewer cases are being brought on this basis, and many of those that are brought forward are mowed down with a motion to dismiss. Many of the Corwin cases decided since the foundational line of cases explore the outer limits of Corwin's protections. First, Corwin cleansing only applies to the transaction at hand. It cannot be used to exonerate directors for fiduciary duty breaches that are unrelated to and preceded the transaction. Second, we've seen a pretty consistent stream of cases where Corwin has not been applied because of defective stockholder disclosure. Brian will cover that subject in a couple recent cases just coming up. Third, we've also seen a line of cases exploring the requirement that in order for Corwin's protections to apply, the stockholder vote must be uncoerced. In particular, there's a developing doctrine of structural coercion that I think is something we'll want to keep an eye on going forward. And finally, as I noted in the beginning, Corwin does not apply in the situation of a transaction with a controlling stockholder. Entire fairness remains the standard of review there unless shifted by MFW. So now that we're way past the dawn of the Corwin era, if I'm a director of a Delaware corporation, I have good reason for feeling pretty protected as long as Corwin applies to my transaction. But what happens if Corwin is found not to apply for some reason? Should Brian do it? Do I need to be worried?
Well, actually, there's a backstop, and that's the Cornerstone case, which was also authored by Chief Justice Strine in 2015. So even if Corwin doesn't apply, for example, the stockholder vote wasn't fully informed, the claims against the directors may still be subject to dismissal on the pleadings as a result of a DGCL Section 102B7 exculpation provision and what is known among M&A litigators as the Cornerstone Doctrine. The doctrine came out of the Cornerstone case in which the Delaware Supreme Court affirmed that a plaintiff seeking only monetary damages must plead non-exculpated claims against a director who is protected by an exculpatory charter provision to survive a motion to dismiss. And that's regardless of the underlying standard of review for the board's conduct as a whole, be it Revlon, Unical, the entire fairness standard, or the business judgment rule. In other words, where a corporation has a 102B7 exculpation provision, in order to successfully plead a fiduciary duty damages claim against a director, the plaintiff must show that the director was self-interested, lacking in independence, or acting in bad faith, regardless of the standard of review. Now, taken together, this means that a plaintiff not only has to plead around Corwin, but they also have to plead around 102B7 exculpation provisions in order to survive a motion to dismiss by directors. But quick reminder, as we'll see in a few cases today, officers are not covered by exculpation. So we saw a good example of the power of the twin effects of Corwin and Cornerstone in the USG Stockholders litigation case, where USG Corporation, a drywall and construction materials manufacturer, agreed to be acquired by a German company, NAF, in an all-cash acquisition for $44 per share. Now, throughout the negotiations with NAF, the board repeatedly said that it viewed the intrinsic value of USG as $50 per share. However, NAF refused to go above $44 per share and turned up the pressure by mounting a successful withhold the vote campaign against USG's director nominees. Now, USG's board couldn't find any other bidder willing to pay more than NAF, and faced with the prospect of a potentially hostile takeover for even less than NAF was offering, the board approved the transaction at $44 per share. Now, following the acquisition, the plaintiff stockholders bring suit against USG's board for breach of their fiduciary duties. And on a motion to dismiss, Vice Chancellor Glasscock dismissed all the claims against the board. First, he looked at Corwin, and he found that the stockholder vote here was not fully informed. The proxy statement failed to tell the stockholders that the board viewed the intrinsic value of the company as $50 per share, even though they also thought that was unachievable. But second, Glasscock looked at the company's 102b7 exculpation provision and the cornerstone doctrine. The disclosure deficiencies here were enough to plead around Corwin, but not enough to show bad faith. You need to demonstrate a director's conscious disregard for his or her duties. That's the standard here, and there is no allegations of that. And that's the critical distinction. Corwin only requires showing that some material information was missing. Cornerstone requires scienter, bad faith, in making that admission. Since that wasn't pled here, the motion to dismiss was granted in its entirety. Now, the backstop protection offered by Cornerstone doctrine is not absolute, and there's two main reasons why. First, officers may still be subject to potential liability. That's because 102b7 does not permit exculpation of officers for monetary damages from a breach of the duty of care. And increasingly, we are seeing plaintiffs who may have brought claims targeting the board in the past are now shifting focus and including officers in their claims as well. There's quite a few cases last year, some of which are listed here, where that was the case. And second, advisors may still be subject to aiding and abetting liability. Although 102b7 eliminates monetary damages, it doesn't remove the underlying breach. Those underlying breaches can still serve as predicates for aiding and abetting claims, as we saw in the now infamous rural metro case. And recently we saw two cases which illustrate these points very well. First of those is the Mindbody case, in which Vice Chancellor McCormick noted in her decision that the case illustrated the paradigmatic Revlon claim, a conflicted fiduciary who is insufficiently checked by the board and who tilts the sales process toward his own personal interests in ways inconsistent with maximizing stockholder value. So the case arose from a 2019 sale of Mindbody to Vista Equity Partners in a take-private transaction for $36.50 per share. And although Mindbody was a publicly traded company, it still had substantial involvement from its CEO and founder, who controlled 20% of the voting power and chaired the board of directors. At the end of 2018, the company completed a fast-moving sales process and ultimately was acquired by third-party Vista in a transaction approved by the stockholders. Now, the plaintiffs in this case brought breach of fiduciary duty claims against three people. First, the CEO and founder. Second, the CFO, who was not a director. And third, against one of the directors, who was appointed by the 25% stockholder, IVP, that was looking to exit its investment in Mindbody. Now, the main thrust of the plaintiff's claims here is that the CEO and founder, aided in some way by both the CEO or CFO and IVP's director, pushed through a flawed sales process to Vista. That was done because the CEO here had massive liquidity needs. 98% of his net worth was tied up in Mindbody stock, and he complained in an email to his financial advisor, also acting as his therapist, that selling his shares slowly through his 10b5-1 plan was like sucking through a very small straw. Definitely not enough to support the millions of dollars of loans and expenses he had accumulated. Furthermore, after meeting with Vista, the CEO thought their presentation was mind-blowing, as he told people in emails afterwards, and he proceeded to take every step he could to tilt the sales process in their favor. He had the CFO lower earnings guidance to depress the stock price and make it easier for Vista to present an attractive bid. He gave Vista thousands of documents in diligence while other bidders received less than 40. And he also disappeared on vacation for almost all of the go-shop period as summer without cell reception, to just name a few. Now, these claims go before Vice Chancellor McCormick, and she finds that the claims as to the CEO and CFO survive the motion to dismiss. First, as to the CEO himself here was clearly conflicted and purposefully withheld material information from the board throughout the process, which she found constituted a fraud on the board. But second, as for the CFO, because 102b7 doesn't permit exculpation of officers, all you need to plead is a breach of the duty of care, which only requires a showing of gross negligence. And she found it was reasonably conceivable that while the CFO's complicity in lowering earnings guidance was at the very least grossly negligent. Third, as for the director appointed by the largest stockholder, IVP, he did have the benefit of a 102b7 exculpation provision, and because the plaintiffs failed to plead either a breach of the duty of loyalty or bad faith, the claims against him were dismissed based on the Cornerstone doctrine. So this case demonstrates nicely why Cornerstone and 102b7 can protect directors, but that protection does not extend to officers. We're seeing more and more claims targeting those officers. Second, for a case illustrating aiding and abetting liability, we return to the Morrison versus Barry Saga, which we have discussed numerous times before in M&A Update. This is a very similar case to Mindbody. The company, the Fresh Market, was taken private in a transaction orchestrated by the company's founder, Ray Barry, where he repeatedly tilted the sales process in favor of his preferred buyer, Apollo Global Management. And in prior decisions in this saga, we learned that first, Corwin didn't apply, the stockholders' vote was not fully informed. Second, the claims against the directors were dismissed due to a 102b7 exculpation provision. And third, claims against the officers, specifically in this case, the general counsel and the CEO, were not dismissed because they did not have the benefit of a 102b7 exculpation provision. So the final question before the court is, will anyone have to face claims for aiding and abetting liability? And the answer here is yes. Aiding and abetting claims survived against the board's financial advisor, JP Morgan. Although the board itself was exculpated under 102b7 for monetary damages for the breach of the duty of care, that did not remove the underlying breach of their fiduciary duties in the Revlon context. The board here failed to investigate JP Morgan's relationships with Apollo, the buyer, and JP Morgan aided and abetted that breach by providing an artfully drafted conflicts memo, which did not disclose the $116 million in fees it had received from Apollo in the last 2 years. And it also failed to disclose that throughout the sales process, it had back-channel communications with Apollo, giving them inside information on how the process was going. As for the target's law firm, Cravath, they got off the hook because they did not intentionally and knowingly, that's the standard here, cause the board to release a 14D9 with material facts submitted. And finally, the buyer got off the hook for the same reason. They didn't misrepresent their conversations with the Barrys. In fact, they repeatedly told the board that they were having those side conversations with the founder throughout the process. So the claims against JP Morgan survive, claims against Cravath and Apollo are dismissed, and we're left with a very important lesson for all M&A advisors. And that is that even with Corwin and Cornerstone, as an advisor to a board in M&A transactions, you need to ensure that you are helping the board meet their fiduciary duties, even if the monetary damages are exculpated. Okay, next up, controlling stockholder transactions and the MFW safeguards. Folks, we've talked about this line of cases before, but before we dive into the new developments, let's take a minute to go through some of the background.
Hey, thanks, Brian. So prior to MFW, under Delaware law, as established in Conn v. Lynch Communications, a transaction between a controlling stockholder and the corporation, or the corporation's non-controlling stockholders, is subject to Delaware's highest judicial review standard, entire fairness. In a transaction subject to the entire fairness standard of review, the controller must establish that the transaction was both substantively fair, that's fair price, and procedurally fair, the so-called fair dealing test. Remedies available to prevailing plaintiffs include injunctive relief and restitution. Conn v. Lynch also established an independent negotiating structure that can shift the burden of proof from the controller to the party challenging the transaction. Under the Lynch doctrine, using a special committee of disinterested directors to negotiate with the controller, or conditioning the transaction on approval by a majority of disinterested stockholders, a majority of the minority vote, shifts the burden of proof to the plaintiff. Instead of the controller bearing the burden of proving entire fairness, the plaintiff must prove that the transaction did not meet the entire fairness test. But even where the Lynch doctrine's minority protections are employed and the burden of proof is shifted from the controller to the plaintiff, determinations of fairness almost always involve significant questions of fact. This makes them poor candidates to be knocked out with a motion to dismiss. As a result, a pre-MFW controller transaction promoted the same incentive to exploit the built-in settlement value as we saw with Revlon cases in the pre-Trulia, pre-Corwin era. One of the threshold determinations in these cases is whether or not there is a controller. In previous editions of M&A Update, Bryn and Brian have exhaustively covered the twists and turns of the controller analysis. This slide describes Lynch's two-pronged test for determining whether or not a stockholder is a controller and the circumstances in which a group can be deemed to have formed and collectively exercise control over the corporation. Application of Lynch's control test frequently involves an extensive investigation of the facts and circumstances surrounding the totality of the stockholders' relationship with the corporation. Delaware courts applying the Lynch test have yielded a scatterplot of results, finding in one case that a stockholder holding as little as 18% of the outstanding stock was a controller, finding in another case that a 46% stockholder was not a controller. In Con v. M&F Worldwide, better known as MFW, the Delaware court affirmed the Court of Chancery's application of a new unified approach to controlling stockholder cases. Where the following conditions are satisfied, a transaction with a controlling stockholder will be reviewed using the business judgment rule and not the entire fairness doctrine. First, the controller must condition the transaction ab initio, that is, from the beginning, on special committee approval and majority of the minority stockholder approval. The special committee must be independent and it must be fully empowered to evaluate the transaction. This includes the right to hire for the committee to hire its own advisors and to reject outright the transaction proposed by the controller. The special committee must act with care. And finally, this will sound familiar from our discussion of Corwin a few minutes ago, the majority of the minority stockholder vote must be informed and uncoerced. In the 2014 Cetra case, MFW's unified approach was applied to a differential consideration case. So this was not a controller case. That is, it was a sale of the company, not to the controlling stockholder, but to a third party, but in which the controller received different consideration than the other stockholders received. The 2019 Olnick case examined the ab initio requirement, determining that once substantive economic negotiations have commenced, it's too late to put the MFW procedural safeguards in place, and entire fairness will remain the standard of review in that case. So with that background, Brian, I think you're going to walk us through a couple recent MFW cases.
Yeah, that's right. So we saw two cases that dealt with the ab initio requirement and also what happens when the controller negotiates directly with the minority stockholders. And the first of these cases was the Dell Class V stockholders litigation. And this case arose from a situation where Dell controlled 82% of the voting power of VMware. However, Dell only controlled 29% of the value. The remainder of that value that corresponded with Dell's ownership was held by a special class of tracking stock, Class V stock, which tracked the value of VMware. So with this background, Dell, as the controller, decided it wanted to redeem the Class V stock and consolidate its holdings of the value of VMware. So Dell pursues the redemption, and it does so purportedly by following the MFW safeguards with approval by a special committee of disinterested directors and approval of the Class V stockholders, the minority stockholders. However, if redemption talks failed, Dell threatened to use a forced conversion mechanism to accomplish the redemption anyways. And with that threat hanging out there, the special committee negotiated a redemption at $109 per share. But the minority stockholders here did not support that. And after Dell negotiated directly with the minority stockholders, they reached agreement to accomplish the redemption at $120 per share, which would seem to be a good thing, almost a 10% increase in the price. Now, the plaintiffs bring suit, and they bring claims against the board and the controlling stockholder, who then move to dismiss based on MFW. And this goes before Vice Chancellor Laster, and he denies the motion to dismiss. First, the special committee was not fully empowered to say no. If the redemption talks failed, Dell had threatened to accomplish it anyways through a forced conversion. And second, it wasn't clear that the special committee was even independent. But third, and even more important to take note of, I think, is that Laster said that the controller cannot bypass the special committee and negotiate directly with the minority stockholders. He said, quote, MFW's dual protections contemplate that the special committee will act as the bargaining agent for the minority stockholders, with the minority stockholders rendering an up or down verdict on the committee's work. Those roles are complements, not substitutes. A set of motivated stockholder volunteers cannot take over for the committee and serve both roles. Now, the reason for this distinction? Essentially, special committee directors still owe fiduciary duties, and the minority stockholders do not. So even with the nice result of the minority stockholders here negotiating a higher price, that is them stepping into a role that is not theirs. Now, of course, note that the fact that minority stockholders did ultimately approve this transaction would likely hold weight in a later evidentiary hearing on entire fairness. The controller just doesn't get the benefit of dismissal in the pleadings under MFW, and therefore has to face what could be an expensive trial. Now, we saw another case, this time by Chancellor Bouchard, that also echoed this distinction, and that's the home-fed stockholders litigation. This is a much more classic stockholder controller-led buyout, the 70% stockholder buying out the remaining 30%. And again, they purported to follow the MFW safeguards and moved to dismiss the minority stockholders' claims. Now, there are problems here again with the ab initio requirement. The special committee and the MFW safeguards were not in place before substantive economic negotiations took place. That's the test that John just mentioned. But even if they were, in dictum, Bouchard cited Laster and Dell and said that wouldn't have mattered because in this case, the controller went around the special committee and negotiated directly with the minority stockholders, and you cannot do that. So the important points from these two cases are that for the MFW safeguards, if you're trying to avail yourself of the protection of MFW, you need to follow the requirements to a T. And the controller also cannot negotiate directly with minority stockholders. All right. Amelia, in our last M&A update, we discussed the impact of the COVID-19 pandemic on case law, and now almost a year in, since things shut down in the US, we have a few new updates for you in that regard.
We do, but first we'll take a step back and reflect on where things stood pre-pandemic with respect to MAE clauses. So when we had material adverse change and material adverse effect clauses, even those drafted broadly have historically been interpreted very narrowly by our Delaware courts. So to show the occurrence of an MAC or an MAE, the party seeking escape from the contract must show that the adverse change is significant, long-term, durational, and not foreseen. Prior to 2018, no Delaware court had ever relieved a buyer from performance based on a MAC or MAE condition. But then, of course, we had our Acorn case, which made big news in Delaware, and I know was covered extensively in a prior M&A update. However, as practitioners, we kind of felt that Acorn should be viewed more as an outlier, basically due to the very extreme facts there, and we didn't think it was going to really have a large practical impact. But then, of course, this pandemic hit, which made us then go back and look again at these MAE provisions. When the pandemic hit, last year, there were over 150 significant M&A deals pending, representing over $500 billion in economic value. So as you can imagine, we had numerous busted deal claims brought, some of which are still pending. So we were just kind of waiting to see when we were going to actually get an opinion out of Delaware based on COVID. And finally, we got a busted deal claim with AB Stable versus MAPS Hotels and Resorts. This was the first case where the pandemic had actually allowed a company to walk away from a contractual obligation. However, it ended up not actually being through the use of the MAE provision. As I said, there were other cases that came up throughout the year, raising very similar issues. Most of them have all settled prior to actually getting a court decision. So as for background on our AB Stable case, here we had MAPS Hotel and Resorts 1. They entered into a sale agreement in September 2019, so pre-pandemic, to buy the owner of 15 luxury hotels from AB Stable. Closing was set for April 2020. As we know, the pandemic hit. This was the hotel industry, so clearly an industry that really took a hit due to the pandemic. MAPS wanted out. They asserted that AB Stable had failed to comply with the reps and warranties and therefore had no obligation to close. AB Stable brought suit, and after a week-long trial, we got almost a 250-page long opinion. This was with Vice Chancellor Laster. First, MAPS argued that AB Stable had suffered a material adverse effect, and therefore, due to the pandemic, it rendered the no MAE rep to be inaccurate. Here, Vice Chancellor Laster found that although, yes, the pandemic had an effect that was both material and adverse, it actually fell within the contractual exceptions of being a natural disaster or a calamity. The interesting thing here was that both of those exceptions didn't actually use the term pandemic in it, but the Vice Chancellor looked at the dictionary definitions of those terms and found that the pandemic clearly fit. So the takeaway here is that the commonly used natural disaster carve-outs from MAE definitions will pick up the pandemic. So the next claim that that MAPS brought was that AB Stable had failed to comply with the covenant to conduct business in the ordinary course consistent with past practices prior to closing. Here, the court agreed that all the hotel closures and other extraordinary measures that had to be taken by AB Stable due to the pandemic, those had actually caused a breach of the ordinary course covenant, and MAPS was able to walk away. Here, due to the contractual language in the sales agreement, industry practice did not play an impact on the analysis. Namely, it was the inclusion of the consistent with past practices language. That meant that the court was looking at the past practices of AB Stable and not at what peers in the industry were doing as a result of the pandemic. The language in the sales agreement also lacked any commercially reasonable efforts, qualifiers, or anything to that nature. A couple of other just notable points from the case. MAPS was also allowed to walk away because AB Stable had failed to satisfy a contractual title insurance condition relating to some pretty egregious historical fraud by AB Stable. MAPS was entitled to a return of its deposit and awarded attorney's fees. And finally, Vice Chancellor Laster here described in great detail, which is one of the reasons why the case was so long, AB Stable's counsel's repeated failure to inform MAPS and its counsel of its clients' very fraudulent activities. And they really were just very misleading in the way that they dealt with MAPS counsel. This here, I think, provides some really good practice points on kind of what not to do if you have a client who's engaging in some pretty bad behaviors. So John's going to take us now through some drafting pointers that we can take away from the pandemic.
Yeah, thanks, Amelia. So as you noted, Amelia, the AB Stable case relates to that slice of transactions that had been signed at this time last year, but had not yet been closed when the first significant public health response to the virus started to be implemented in mid to late March of last year. The M&A market at that time basically was put on pause in mid-March, and when deal activity picked up again, we started to see the development of several modifications to the terms of M&A purchase agreements in reaction to the pandemic and some of the cases that were starting to percolate in Delaware around busted deals, including AB Stable. I think taken as a whole, these drafting trends reflect an emerging consensus view that the risks of the pandemic to both the general economy and to specific businesses or industries are much better understood now than they were a year ago, and that deal parties that are in the process of transacting now have the ability to allocate that pandemic risk amongst themselves. So some of these drafting trends that we've seen include modifications to two of the key definitions, one of them being the MAE or the MAC, material adverse effect or material adverse change. And despite the Vice Chancellor's suggestion that you can get by without a specific exclusion from the MAE definition tailored to pandemics, we've seen a lot of explicit pandemic carve-outs to the MAE definition. The other thing the other definitional issue folks are spending a lot of time thinking about is the ordinary course of business definition, particularly because of the role that definition played in the analysis in AB Stable, and with a focus on that little phrase consistent with past practice and what that means and the significance of it. There's been a renewed focus, I would say, on the interim operating covenants. I think pre-pandemic, this was maybe a section of the agreement that got glossed over, kind of skipped over without much thought. And given that, breach of that very covenant is formed, a big part of the basis for the AB Stable decision, people are taking a hard look at that provision and, making sure that from the sell side, you're in a position to be able to comply with that covenant. We've also seen some modifications to other interim operating covenants, like the seller covenant to provide buyer with access to employees, facilities, and records. And finally, we've seen some different approaches to addressing the reps and warranties. Some of the approaches I've seen in my practice range from trying to include a global qualifier to the reps that's targeted to the pandemic, to an approach where there are more targeted adjustments throughout the reps, or an approach where you just try and address all the pandemic effects in disclosures that are made in the disclosure schedule. So with that, Brian, I know you have a code to share with us.
Next up, we saw another interesting case recently dealing with attorney-client privilege in M&A transactions. So just to refresh, as you know, when a lawyer represents a target in an M&A transaction, the attorney-client relationship, privilege, right to waive it, right to confidential information files follow along with the target and go under the new owners. And that's important because if there's post-closing disputes, buyer will now have access to deal files, communications, work product, and may be able to use those against the seller. So what do you do? Well, we've seen in the merger context that if you include a provision in the merger agreement that preserves the privilege for the benefit of the seller, the courts will enforce that. That was the SRS versus RSI Holdco case that we discussed a couple years back. But that's in a merger context. What happens in an asset sale where buyer acquires substantially all of seller's assets, including their emails with counsel? Well, we had just that case this time in DLO Enterprises where buyer acquired substantially all of seller's assets related to a flooring business. A post-closing indemnification dispute arose, and the question before the court was whether buyer acquired privilege from sellers. And note here that there was not a specific provision in the agreement dealing with privilege. So there's three categories of information at issue. First, pre-closing deal communications that were not in buyer's possession. Second, pre-closing deal communications that were in buyer's possession because they had acquired all of seller's emails. And third, post-closing communications with counsel that were done on buyer's email system. So one of the sellers had continued to work for the buyer post-closing and also continued to email their counsel. So who controls the privilege? The answer is it is complicated. So for the first category 1 communications, the emails not in buyer's possession, Vice Chancellor Zern found that sellers retained the privilege. And in doing so, she said that the default rule was that in the asset purchase context, the seller will retain pre-closing privilege regarding the agreement and negotiations unless the buyer clearly bargains for a waiver or a waiver right. For category 2 communications, emails that were in buyer's possession, she found that was a closer call and requested additional briefing, noting that the proper test may look at whether sellers waived privilege when they transferred the emails to buyer at closing, or whether the purchase agreement specifically dealt with it. So she stops short of saying it, but implies that a provision specifically preserving privilege like you see in the merger context might have been effective here, but there wasn't one. For category 3 communications, the post-closing emails with their counsel on buyer's email system, that's not looking so good for sellers. The sellers did not have any reasonable expectation of privacy when using buyer's emails to email their counsel, and unless a state statute can swoop in and change the analysis, buyer can likely access and use those communications. So where does that leave us? Well, best practices on attorney-client privilege. First, address it directly in the purchase agreement. And there's a number of good forms out there that you can use, which cover some of the points on this slide. Second, if it's an asset sale and you can prevent it, hold that information back. Don't deliver it over to the buyer at closing. And third, if you represent a seller and they continue to work for the buyer post-closing, make sure to use a different email account when you communicate with them regarding any post-closing communications. Okay, shifting gears a bit here, we saw another case with some pretty important drafting lessons, and that was in the context of fee shifting provisions, John.
Yeah, that's right, Brian. So this Ashland case presents a rather routine fact pattern. I think it'll, sound familiar to many of us. Ashland, in the underlying deal, Ashland acquired a specialty chemical and ingredients manufacturer for $3.2 billion. As part of the transaction, the sellers agreed to take responsibility for cleaning up a problem property located in Linden, New Jersey. Following sellers' failure to remediate the property, Ashland brought a claim for indemnification under the purchase agreement, which was Ashland's sole remedy under the agreement for covenant breaches. Ashland ultimately prevailed, with the court agreeing that the sellers had breached their obligation to clean up the Linden property and that Ashland was entitled under the purchase agreement to be indemnified for that breach. Ashland then brought an action to recover its attorney's fees. So this next slide shows the key contractual provisions from the agreement. First, we have the section establishing buyer's right to be indemnified, defended, and held harmless for certain capital L losses, including losses resulting from the seller's failure to perform under the cleanup covenant. The slide also shows the contract's definition of losses, which you'll note specifically includes reasonable attorney's fees and the highlighted modifier, whether or not involving a third-party claim. Now, this is perfect pop quiz material. I'll ask you to consider the following question in the privacy of your own home office or garage or wherever you're tuning in from. Is Ashland, and remember, what Ashland has is a direct indemnification claim against sellers for the seller's breach of their covenant. It does not involve any other party. Is Ashland entitled under the contract to recovery of the reasonable attorney's fees that Ashland incurred in bringing its indemnification claim? My guess is that many of us would expect, as Ashland surely expected, that the definition of losses indicated pretty clear intent that Ashland would recover reasonable attorney's fees in a successful indemnification claim, and that the phrase, whether or not involving a third-party claim, was intended to make clear that recovery for losses was available regardless of whether a third-party claim was a source of Ashland's losses or not. Well, surprise. Holding that the party's intent to override the American rule and shift fees was not clear and unequivocal, the Delaware Superior Court determined that Ashland was not entitled to recover its attorney's fees. So, note to self, note in the margin here, if you're involved with a deal that's in process now and the purchase agreement isn't fully baked, I'd encourage you to budget a little think time to look over this provision in your agreement and see how it squares up with the intent of the parties. So, Amelia, I think it's back over to you for some alternative entity case law.
Yes, thank you, John. So basically the big news I'd say this year in alternative entity case law was that USA cafes still stand. So to back up a minute quickly and just to go through how fiduciary duties work for alternative entities, because they are a little bit different than corporations. So by default, managers and controlling members of a Delaware LLC and a general partner of a Delaware limited partnership, they owe the same fiduciary duties as those owed by a board of directors of a Delaware corporation. So we're talking about the duties of loyalty and care. The difference with alternative entities is that fiduciary duties can be modified and even eliminated in an LLC or partnership agreement. Whether or not we want fiduciary duties to be eliminated or modified, it's going to depend on a number of things, really the nature of the relationship among the parties, which party has more negotiating power, and kind of what's typical for market standards for the type of transaction we're entering into. Typically, management prefers to have their duties eliminated, and a more passive investor would prefer for the manager to have traditional fiduciary duties. Right now, we're seeing a lot of LLC agreement case law where the court is looking at fiduciary duties that have been eliminated and then replaced with what we call contractual duties. So that's where we'll see a lot of case law looking at what does the duty of good faith mean? And it really depends on how that contract is actually drafted. So with that background, we'll look at what is the USA Cafes analysis. This comes from USA Cafes LP litigation, which was a 1991 Chancery court case with then Chancellor Allen. He held that where a general partner of a limited partnership is a corporation rather than a natural person, the directors of the corporate general partner will owe a fiduciary duty of loyalty to the limited partners. So what this does is when we have an alternative entity like an LLC or a limited partnership that has a manager or general partner that isn't a natural person but is another entity, which is really common in the alt entity context, it allows the court to break through that chain of entities and go up the chain until you reach the actual person who's making decisions and hold them responsible for the decisions being made. Notably, this does not apply to the duty of care. We're just talking about a limited duty of loyalty. The USA Cafes doctrine has been subject to a lot of questioning and criticism over the years, including by the former Chief Justice Strine and Vice Chancellor Laster. They were quoted in an article as saying that the concept leads to an odd pattern of routine veil piercing. A lot of people argue that it's contrary to the separateness aspect of alternative entities and goes beyond what the parties to the LLC and partnership agreements have bargained for. But despite this criticism, USA Cafes lives on. This year we had multiple cases which upheld USA Cafes and even expanded it. Just to touch on one briefly, we had 77 Charters versus Gould. This involved a dispute amongst investors who acquired a shopping mall together. Here we had the defendant, Jonathan Gould, and the various entities that he controlled that actually ran the day-to-day operations of the LLC. Gould, though, was a managing member of the Delaware LLC at the bottom of the chain. So again, he was up the chain of entities. Here we had a preferred investor that wanted out. Gould found a replacement. He himself bought the preferred interest and then used that time to amend the LLC agreement to change the waterfall, really to the benefit of the preferred. Then he sold a portion of the preferreds, again, keeping some for himself. They ended up then selling the shopping mall, and our plaintiff here, 77 Charters, was out of the money. They received nothing in the sale. So they brought suit. Unfortunately for them, it seems like their counsel didn't do a great job. Most of their claims actually failed. And really the court kind of said they were poorly drafted. The court did, however, find that Gould's amendment to the LLC agreement, where he adjusted the waterfall, may have constituted a self-dealing transaction that was not entirely fair to 77 Charters. So that really limited fiduciary duty claim did survive the motion to dismiss. Again, Gould here, who was held responsible, was not a member or manager of the LLC, but the court found that under USA Cafes, he could owe limited fiduciary duties to the extent that he exerted control over the assets of a subsidiary. So USA Cafes survived. As I said, it was in a handful of other cases this year as well, and even found to apply in the statutory trust context.
Excellent. Wow. Thank you, Amelia. That is great to know and keep track of. All right, folks, we are reaching the end of our time here today, but the new 7-person Chancery Court authoring the most opinions ever in a year last year. There are a few additional cases which are important for the M&A practitioner to be aware of. We've included those here as quick hitters, which we'll just touch on briefly, but commend to your perusal. First, Section 220 demands in the wake of corporate wrongdoing are expected to rise. So in almost every Corwin and Mfw case we talked about today, they were preceded by a 220 demand before closing. And the Delaware Supreme Court in the Amerisource versus Bergen case held that when the purpose of an inspection of books and records under Section 220 is to investigate corporate wrongdoing, the stockholders seeking inspection is not required to specify the ends to which it might use the books and records. So that is a very important decision, could expand what stockholders are going to be seeking in the books and records demands that they make. So something to watch for. Second, there's a federal court, District of Connecticut, that actually dismissed claims brought by plaintiff stockholders that the proxy statement was material misleading. These were brought under Section 14 of the Securities and Exchange Act. One of the reasons that we talked about at the beginning, the Trulia case, when plaintiffs have found that Delaware courts adopt that strict new plainly material standard, they try to bring the claims in federal courts. And it's looking now like federal courts may not be as friendly as a forum as originally thought. So those claims could be decreasing further. Second, just something to note is that directors are presumptively entitled to communications between management and company counsel. This is in part of the litigation stemming from what is happening over at WeWork, where the directors were found to be presumptively entitled unless there's a board process to exclude certain directors, such as setting up a special committee of directors that have their own counsel. But management cannot curtail the ability of directors to access counsel communications unilaterally. So something important to note. And last, we've touched on this before, but Caremark duty of oversight cases are on the rise. There was 2 new Caremark cases that recently survived motions to dismiss, which subjected the directors to potential litigation for potential personal liability for breach of their duty of loyalty failures. So just a reminder for boards out there to establish and document oversight over critical areas. And with that, on behalf of Amelia and John, we would just like to say thank you. We look forward to speaking with you again in August at the next edition of the M&A Update. Thank you.
Thanks, everyone.